Okay, now we're going to finish up Chapter 10 and talk about strict product liability. And strict product liability in tort is talking about when a person is injured because of the use of a product. There is no liability needed to show for all the parties that can be affected. It can be the manufacturer, the distributor, or the retailer. It is based on production defect, a design defect, maybe a failure to warn. Much of the following material is not in the text, so you need to listen to this video and read and watch the PowerPoint. Strict product liability is the liability of manufacturers, distributors, sellers, anyone else in the chain of distribution that distributes and sells a product that ends up injuring a person. Remember, under negligence, there had to be 5 elements to prove negligence. There had to be duty, breach of duty, there had to be injury, there had to be actual cause, and there had to be approximate cause. But how do you actually find out who was negligent in a product that goes through a series of hands? Because the user or the person injured may not even have purchased it. They may be a bystander. They may be using it as a family member of the person that purchased it, something like that. There could be no privity of contract. And therefore, it was getting very hard to show and to find the person that was negligent. The courts and the legislatures came up with the strict liability. Strict liability is imposed irrespective of fault. Liability without fault. Liability regardless of the degree of care of the party. And as we'll see, that the parties in a commercial chain may have done everything that they could, may have no negligence at all, and may be nothing more than have bought the product and sold it to somebody else. But they will all be held responsible, all liable, when a person is injured. That's strict product liability. And there is no privity of contract. There does not have to be a relationship between the party that ends up paying and the party that was injured. By chain of distribution, we mean the manufacturer, the distributor, the wholesalers, the retailers, and then the consumer. The consumer is injured, or a bystander, or a person that is using the product that the consumer bought themselves can bring an action against anyone in that distribution, even though it may have been only the manufacturer that was negligent. But everyone else in that chain of distribution will be a defendant and can be held liable. The non-negligent parties have the right of contribution against the negligent party. So it's not like everybody is going to lose out on it, but the consumer is not the one that has to decide who is going to pay. No privity of contract is required. Users include a purchaser, family members of the purchaser, guests, employees, customers, those that are passively enjoying the product, the benefit of the product, i.e. passengers in a car, if they're injured, they can sue the person, the manufacturer, the wholesalers, everybody in that chain of distribution. Most states now include bystanders. So if a person is walking along the sidewalk and there's a power mower and it throws a rock out because there was a inadequate design, or a piece of the mower was left off when it was sold, and the rock flies off and hits a person in the head or the eye, then that bystander can also bring a lawsuit against anybody in that chain of distribution. Claims are for a defective product. The defects in manufacturing, in design, failure to warn, or failure in packaging. Failure of design in manufacturing is fairly straightforward. It was improperly assembled, fails to properly test a product, they didn't check the quality of the product, a bolt was left loose, a piece was missing, whatever, and that was the cause of the injury. Product and design says that, for example, automobile manufacturers have to design a car anticipating that there may be an accident and making it safe on the inside. Defects that occur when a product is improperly designed. You see a lot of this in some heavy manufacturing type where there's injuries in factories and things like that, where the manufacturer did everything that was supposed to be done, There were no loose bolts, everything was attached, but the design of the equipment was dangerous for the operator, and somebody was injured, and then again everybody will be strictly liable because of that injury. Failure to warn occurs when a manufacturer does not place warning labels on a product. This can be seen very commonly in drugs. Cancer-treating drugs have very dangerous side effects, but you can't reduce those side effects and still have an effective treatment for cancer. So it's important for the manufacturer and everyone in that chain of distribution to be aware and make sure that the end consumer is warned of all of those side effects. It's almost like an issue of assumption of the risk. A person can assume the risk of the side effects when they know what they are and they want to use it because of the effect on cancer or another ailment. A defect in packaging occurs when a packaging allows it to be tampered. The Ellsworth v. Johnson & Johnson case, the Tylenol case, where somebody deliberately went in and poisoned the Tylenol. In that, the first case, the Johnson & Johnson was liable. In the second case that came up, the court found that they had done everything they could to protect the packaging, and so they were not held liable the second time. There are defenses to product liability, supervening or intervening event. This is very important, especially when you're in the in business. Substantial changes of the product from one level of distribution to the other absolves all prior sellers from liability. So, for example, if the manufacturer shipped out a lawnmower that was made well, it went through the distribution channel, and one of the employees at Home Depot decided that a certain part was impeding the blades or wasn't needed or something like that, and they took that part off, and a person was later injured by it, or they loosened the bolt from the blade and it flew off and injured somebody. Home Depot would be liable, but everyone prior would not be liable because they were not responsible for the change that had been made. But anyone that accepts the product and then sells it down the distribution chain will be held strictly liable. Also, a defense to a product liability is generally known. Dangers, guns are dangerous. Somebody shoots themselves in the foot. They look at it and say, well, you knew if you pointed it at your foot and pulled the trigger, you'd be injured. Government contractors, if the government provided specific specifications, a company manufactured it, they didn't know of the defect, or if they did, they warned the government of it, then the manufacturer will not be held liable. Otherwise, the government would not be able to get the instruments of war that they want, which are sometimes very injurious of bystanders. Defenses to product liability is assumption of the risk. The plaintiff knew of the risk and unknowingly assumed it. That's what we talked about under contract law, under the tort law for negligence. So you can have the assumption of the risk of product liability. Misuse of the product, if the plaintiff used the product for an unforeseeable use, an abnormal use. There was one case where a person was going to a Halloween party and wanted to go as a bunny rabbit, and they took cotton balls and pasted them all over their body. They went into the party, somebody was smoking, they got lit on fire and were severely burned. They sued the manufacturer and the distributor of the cotton balls, and the jury said no, that was not foreseeable, that somebody would use them to make them look like a bunny rabbit. Also, a defense for product liability at a certain time would be correction of a product defect. And these are the recalls. Somebody's been injured, the manufacturer, the store has recognized that there's an unsafe product, and then they will send out a recall notice. So they will notify people that that certain products could be dangerous, and they offer to correct the defect, replace the item with a safe item, and that will take them out of product liability for everybody that was injured after the product defect was announced. They use general notice like newspapers, things like that. Even if the consumer did not get actual notice, if they were reasonable in putting their public notice out, they can be not held liable after they've tried to correct it. Okay, defenses to product liability, statute of limitation and statutes of repose. basically the same, but a statute of repose is from the time of the date of sale, and a statute of limitation takes place from the time that the person knew of the defect. A lot of times there are defects that you don't discover right away, and the statute of limitation does not begin to run until the plaintiff knew or should have known of the defect. Contributory negligence does not bar a strict liability, but many states do apply comparative negligence to the strict liability cases. Other strict liability torts are what they call negligence per se, and again, this is where no fault has to be identified, no duty identified. Dram shop acts, tavern owners liable for intoxicated patrons. That dram shop does not owe a duty to the person that was injured because somebody left their bar and hurt them, but it's strict liability, and the person that was injured by a drunk patron of a bar or a tavern can sue that shop. Many states also have social host liability. If somebody holds a party, they're serving alcohol, and a person goes out and injures somebody after that, and then the host can be held liable, as well as the person that caused the accident themselves. Okay, identify and describe the elements of the cause of action based on negligence. I hope you said duty, breach of duty, damage, actual cause, and proximate cause, the 5 elements of negligence. Let's take a quick moment and talk about damages. Anytime there's a tort, there's actual damages. That is, the defendant can actually get paid for all the damages that were caused, medical things like that. Compensatory damages are to compensate the plaintiff for injuries that were suffered. There's past and future medical expenses, the loss, past and future economic losses, pain and suffering, the loss of salaries, things like that. Punitive damages are used to punish the defendant. Remember, in contract cases there are not punitive damages, but in torts there are. It is to punish the defendant, not the plaintiff, to punish the defendant. The award is based on the work of the defendant, not the damage to the defendant. In punitive damage cases, after determining its liability, the plaintiff can discover the net worth of the defendant. That's reversed the other way around. It's actually the defendant can determine what the net worth is of the plaintiff. And the purpose is to punish the defendant for what they did. The Supreme Court has come by and started limiting that to 9-1, although you hear some really high cases, and that's why attorneys love to get the deep pockets. So punitive damages are when the defendant is able to go after the plaintiff for their net worth, not the damage to themselves. There are alternatives to the tort system. There's whole issues of contingency fees. That's where the attorney gets paid a percentage of the award that they win for their client. There are alternatives to just lawsuits. It's arbitration, no-fault insurance, workers' comp. Workers' comp is a state-by-state no-fault program where if a employer is or a employee is injured, then they get a workers' comp claim for the amount of the injury. They do not have to show that they were that the employer was negligent. They get paid anyway, and the employer cannot come by and talk about contribution. It is a no fault. That is, purpose is to limit the amount of injuries or amount of compensation that is paid out. Okay, we'll go on to intellectual property, and then we'll finish up for this week.